Donald Trump's lawyers filed a frantic motion with Judge Tanya Chutkan on Tuesday evening this week, where they effectively begged Chutkan to issue a stay in her case, right? The trial that's supposed to begin on March 4th. They want her to temporarily postpone everything, temporarily but technically indefinitely, until, of course, the time that the United States Supreme Court issues their ruling on whether or not Donald Trump is immune from lawsuits, or I guess in this case, criminal indictments. Now, I'm going to read you just part of the statement in just a minute, but understand this. This is why Donald Trump got so pissed off this week when the Supreme Court said that, okay, we're going to follow Jack Smith's request and we're going to expedite our decision on whether or not Trump is immune from criminal prosecution. So Trump thought before Jack Smith's request, like, oh boy, this is great, right? We get all this time. The Supreme Court may not get to it for 6 months. And in the meantime, I'm going to ask the judge to not move the trial forward at all. And by doing that, I don't have to worry about being criminally convicted, perhaps, till after next year's election. Well, the Supreme Court threw cold water on that, kind of, by granting the expedition request. However, we don't know what expedited means for the Supreme Court. We know that Donald Trump and his team have until December 20th to file their response, but the Supreme Court could still take a week, a month, 2 months, whatever, to issue their so-called expedited response. But here is one of the things that Trump's lawyers put in this filing. On behalf of the Biden administration, the prosecution will do everything that it can to rush to an unconstitutional and fundamentally unfair trial to prevent President Trump from winning the 2024 election, which he is currently leading. So, this is a 9-page brief that they filed with Judge Tanya Chutkan asking for the stay in the case. Now, as legal experts pointed out, this probably could have been done in like 2 or 3 pages, but instead, most of the filing was similar to that. Like, it was just this nonsensical political ranting, accusing President Biden of election interference and talking about Donald Trump's poll numbers and all this other like very, very stupid and totally irrelevant stuff. But at the same time, the legal experts do seem to think that Chutkan will likely grant the stay. And the reason for that is because typically in a case where you do have appeals taking place regarding to the case, it is common for the judge to say, okay, while the appeals are working their way through and we're waiting for those decisions, that, for the record, could end the case. While we're waiting for that, nothing moves forward and all timelines are suspended indefinitely. Now, they do think, as I said, that Chutkan will rule that way. I don't know. I mean, we've seen Chutkan kind of go against the grain a little bit. She's been very quick with her motions. She's been very quick with responding to things, dismissing them, when Trump's lawyers just say the stupidest stuff in their filings. So I don't know that she wants to put this on the back burner. She may want to just say, no, listen, if the Supreme Court comes back a month from now and says you're immune, then it goes away anyway. But in the meantime, there's no reason why we can't just keep working on it and still try to keep that March 4th trial date. So it could go either way. Historically, you typically see them grant the stay, but Chutkan seems to want to make this happen and get it going as quickly as possible. So there's a good chance she dismisses this one as well.